Matter of Stewart, 79.
Good afternoon.
Good afternoon, counsel.
Chief Judge Lippman, may I reserve 2 minutes of my oral argument for rebuttal, please?
Yeah, sure.
Thank you. May it please the Court, my name is Charles D'Angelo, and I have the pleasure of representing Mr. Baytall in this very interesting election law appeal. I'd like to address the issues in order. First, I'd like to address the absentee ballots of voters RY and WY.
All in all, we're talking about 5 votes here?
Yes.
And what's the count without those 5 votes?
Mr. Baytall is down 3 votes.
So you've got to win. You've got to win at least 4 to 1 on these.
I'm hoping to win all 5 today, Your Honor.
Okay, go ahead.
But wait, you're saying that some of them shouldn't count.
I'm sorry?
You're saying that some of them shouldn't count.
Well, if I knock out 4, I'm plus 1. If I get the other one,
Oh, I see. He's down. He's down 3. He's down 3 with what the lower courts did.
Correct.
Okay.
Thank you, Your Honor.
It was a tie after the Supreme Court, right?
Yes.
After the election, it was 1 vote, Stewart was up 1 vote, and then it went to Supreme Court, and then it was tied, and then the appellate division, and now you're down by 3.
Correct.
Right, okay.
Thank you.
Okay, now the absentee ballots. Go ahead.
The Chautauqua County Board of Elections should have first determined whether the voters were entitled to receive an absentee ballot before they sent them out. There is no question here the applications were incomplete.
But ultimately, they did demonstrate that they were entitled to them, right?
Correct, Your Honor. However, not until after.
The applications that came with the ballots,
Correct.
those applications were incomplete? Is that what you're saying is incomplete?
No, Your Honor. They were incomplete when they were first sent in. The Board of Elections
Okay, well,
sent them
that's a
back.
huge distinction from the Gross case that we had, because in Gross, they just sent out the absentee ballots. There were no applications ever received by the Board of Elections. So this is really a step beyond Gross. So you're saying if you send your application in with your ballot, that invalidates the ballot?
I'm saying that Gross, in material terms, stands for the proposition, as I read it, that you can't have an incomplete application in material terms, especially when the terms in question that you didn't complete relate to your eligibility to
but
receive.
this is very...
Go
ahead.
Whether you're aggrieved or not, whether your client is an aggrieved party here, since you took an inconsistent position in an earlier proceeding?
Yes, we feel that we are aggrieved. The process, it was not just one event. It was the process of reviewing the absentee ballots to determine whether, in fact, they should be counted or not. And as the lower court held, frankly, until the ballots were opened, it wasn't clear what was going to happen in terms of what would be in the ballot.
And that's when you saw that the affidavit, the second affidavit, was inside the same envelope. Not folded inside the ballot, but it was alongside in the same envelope.
Correct, Your Honor. Unmistakably.
Do we know if the Board of Elections looked at that application before they counted the ballot?
I didn't hear that, Your Honor.
Do we know if the Board of Elections looked at that application
Did not.
before they looked at the ballot?
Did not, Your Honor. It was before us. The 4 counsel were sitting at the table. Court
So
directed.
it was all open simultaneously.
Correct, and it's unmistakable,
Could
Your
you
Honor.
have objected to that application if, for instance, they didn't put a reason down that would justify why they couldn't vote at their residence?
Certainly could have, but it was very apparent that the extrinsic materials were with the ballot. Your Honor, if clearly maintaining the privacy of voter is the key underlying underpinnings of the law, then having an application that identifies the voter by name, address, phone number fall out with the ballot itself.
But wasn't there a reason, wasn't there a time element here, and that's why it all played out this way? That
No time element.
That they sent it back in terms of with the ballot so that it could come in on time?
No time element other than a normal election. And frankly, Your Honor, like Gross, the concern should be by the court, what I'm asking you to address, is that if you allow for this ballot to be counted with applications going out after the fact with no special time requirements, this isn't a special election procedure like the Gross case. This is an ordinary run-of-the-mill election. What it stands for, unfortunately, if you rule that these ballots are okay, is that applications can go out with ballots and people can receive ballots before they're qualified to receive them.
So you want a rule that the board has to rule on the application before they issue the absentee ballot to the voter?
Absolutely. To read the election law otherwise is to wreak havoc under...
Even though this is different than Gross, you acknowledge that here they do show that they were entitled, and in Gross, they never showed that, right? They just got it automatically and sent in the
I see the distinction, Your Honor, but in principle, you have the cart before the horse in both cases. Applications should not, ballots should not be given until someone is qualified to vote.
So what should have happened? What should have happened here? And the board saw that the application was incomplete. They should have requested the voter to come in, or they should have notified them that it was incomplete before they gave them the ballot?
Yes.
Or suppose they should have only sent them the application, not have sent them the application and the ballot. Is that?
That would be fair too, Your Honor.
But granting
The
that
process followed is just, it's infectious.
you're right, granted you're right about what they should have done. In these cases, a lot of times boards don't do what they should do, and sometimes the remedy is to invalidate the ballot, and sometimes it isn't. Why is invalidating the ballot the right remedy here when we know that these are legitimately entitled absentee voters?
Because to do otherwise is to sanction a process that's not otherwise permitted by the election
Yeah,
law.
but that's true in every case where we overlook some irregularity. There are what I'm saying, there's some we do overlook, some we don't overlook. Why do we put this in category 2?
This is not inconsequential or ministerial in nature. This goes to the very heart of the regulation. Is certainly distinguishable from those inconsequential errors that you find where this court has made exceptions.
Well, they were qualified to vote, though, in the end, right? They filled out, the application was corrected.
Correct.
So they were eligible to put in an absentee ballot. So why isn't it, and I mean this in the broadest common sense perspective, so why isn't it fair to let them vote? They were eligible.
Your Honor, because I don't believe...
Why isn't it technical is what I'm saying.
It's not technical.
Just we're overlooking, you know, they should have done the procedure that you said, but they were eligible. We have their ballot. They didn't mark up the ballot. Why isn't it fair in that circumstance to let them vote?
Because it goes to the very heart of the statute. The statute provides that you have to be qualified in order to receive a ballot.
How did the voters not know that the board wasn't going to look at their application first and then take their ballot?
They didn't fill
If
out...
the board had done that, it would have been fine, correct? I mean, the voter put both documents in one envelope, correct?
Yes.
The application and the ballot is in one envelope. How did these voters know that the board wouldn't open up the envelope, check the application first, and then count the ballot? That would have been okay, wouldn't it?
I think, yes. However, it's the same point that this court made in Gross. It's not as if you're blaming the voters for the mistake. But the practical reality is it's clearly, patently improper what happened here, and you shouldn't and can't sanction it.
So your posture is the ballot can't go out until there's a board determination that they're entitled to vote absentee.
Correct, absolutely.
What if they had been mailed back in 2 separate envelopes? You'd still have the same position?
Interesting question.
There would be no identifying marks.
I would say I take the same position, Your Honor, because the ballot was sent. For me, it's black and white. The ballot was sent.
The error
without
was
qualification.
to send it with the ballot. Okay. Thanks, counsel.
Thank you, Your Honor.
Thank you, Your
Counsel,
Honor.
you want any rebuttal time?
I would. Please, Your Honor, 2 minutes, please.
2 minutes. Go ahead. What issues are you dealing with?
Hey, please, the court, I'll start with the unscanned ballots.
ahead.
It's a brand-new process, Your Honors. There's no case law on it. There's only regulations on it. Part of the issues here is that the voters in question never completed their process. Plain and simple.
But the regulation that there is pretty clear, isn't it? It says if the machine spits out a ballot, count it by hand.
I believe that wasn't the intent of that subsection. I believe you're thinking about 6210.13A8, where it says if it's damaged or torn by the board or their agents, or it's non-machine processable, that it should be read by that it should be hand counted. I believe that that's a different issue. I don't think that was the intent of that particular subsection.
So your argument is that they abandoned those ballots?
That's correct, Your Honor. There are 28.
Wait, how do you get it abandoned when it just pops back out of the machine?
Quite frankly, one of the voters, it popped back out on him, and this happened 28 times in this particular poll site. 26 other times, they handed the, per regulations, per the Board of Elections, they handed them brand-new ballots to fill out.
Well, if I could ask you a general question.
Sure.
It's my polling place, we still use the mechanical. Is there a sign or something that tells people what to do if your voting card comes back out of the machine?
There's actually a poll inspector standing near the area. If it pops back out, they see it, they come over to you, they help you to put it back in. If it pops back out again, I think they may examine the ballot or give you...
Because the one ballot here that has the X's in it,
Yes.
very neatly inside the boxes, it's
Correct.
pretty clear who this person intended to vote for.
It is pretty clear, but it was still unable... First off, they didn't follow the regulations on the card that said to fill it in completely. I believe that there's...
Well, I'm sure we're going to have hundreds of voters that are going to use check marks in the next general election rather than fill in the box.
And I agree with you. And at that point, when that doesn't happen, they are handed a new ballot. And that happened 28 times.
But here, isn't this the perfect example of, don't you want to let the person vote? Because you could see what it is. There's not some crime here, people trying to vote twice or whatever it is. We know you could see who they voted for. Why wouldn't you count the vote? What's it against?
Well, it's against the process of which the Board of Elections is trying to establish.
What
these
process? What process?
These new machines. The beauty of these new machines is that in this election, particularly that I know about, it was 100% accurate. And we were able to check that it was 100% accurate.
So it's okay for the person to fill out a new ballot and you put it back in. But the ballot that they don't put back in that shows clearly how they want to vote, that's not okay, and that makes sense in terms of trying to have the voters' will heard?
They're given the opportunity.
Is that really a technical kind of thing that really deprives people of their right to vote?
Well, it doesn't deprive them of the right to vote if they follow the process. It's just like any other part of the election process. There's a process that needs to be followed.
But in one of the two, the person was really afraid that they would be considered that they voted twice, right?
I don't think that was it. I think he just said, in my opinion, I already voted. I don't want to take the time to fill out a new ballot.
Is his opinion wrong?
His opinion is wrong, Your Honor. The machine never processed that vote, and that's what the machine's supposed to do, is process the
The
vote.
state of New York is supposed to come into compliance by the next general election, correct? But the entire state.
I believe so. You guys are going to have fun.
Well, that's why
I live in New York
we're
City.
so
Oh, my
concerned
God.
about this case, because I'm not so sure that in every polling place there's always going to be an election inspector standing there ready to hand somebody another substitute ballot.
Well, I believe that's the way that it should be, but I guess my question would be, what happens in a Nassau County type election when there's thousands and thousands of ballots that aren't read? Now they have to go through and hand count
So
them all.
what's the standard? What's the standard?
The standard should be that if the vote is unable to be cast, unable to be read by the machine, they should be given a new ballot to cast it. If that's unable...
But in your case, where there are thousands and thousands that aren't read, then if they don't put in new ballots, you throw them away.
They're supposed to be marked void.
Okay, but they lose that. I mean, one of these guys, just somebody who left in such a hurry, he never found out that the machine had not taken
He didn't wait the requisite maybe 15 seconds. The amount of time...
Still, it's not. Why should he have to wait 15 seconds? He thought he voted.
I think it's his duty to make sure that his vote is cast. I mean, it's not as though it's a secret. It says on the screen.
If he doesn't stay 15 seconds, he gets disenfranchised.
It's not a huge burden to place upon the voter to wait for a sign that comes up, a word on the screen that says completed vote.
It's going to take a long time to educate many, many voters in this state.
Unfortunately, that may be the cost of change.
Millions of people.
You may not be able to answer this question, but why were these two ballots not read by these scanners? Because it's not like they're messy,
the one
incomplete.
is extremely messy. There's a lot of overvoting. They go in different lines. They cross over into different votes.
Well,
It's almost
certainly
like a
the
straight
one
scribble.
with the check marks, all the marks were within the square.
They were
Why
within-
wouldn't the scanner pick that up?
Because it didn't fill in the requisite. I think I know there's a percentage of the square that needs to be filled in.
So
I
you
don't know
have
what-
to vote for every office?
No, the percentage of the voter in particular.
You mean each square has to be filled in
Correct.
like 60% or something?
Correct.
There was too much white space left in the squares.
That's correct, because what that does is it avoids, you have to set a line somewhere, because if you just simply place a dot in a...
You're better to be messy than to be neat.
Well, you're better to be messy you're better to be neat within the lines.
How does it determine 60% if you can choose not to vote and it'll accept your non-vote? Like, let's assume you're saying I'm not going to vote for supervisor, so...
I don't think that it registered any of them. It was registered as a blank
but
ballot.
when I'm putting mine in, and we do have these new ones, if I chose not to vote for supervisor, there'd be a blank.
Correct.
You're saying, however, if I chose to vote for supervisor and filled it in halfway, somehow it would reject it.
I think that if it filled it in halfway, and you say you only voted for one office, you left everything else blank, it would only credit you for that one office.
So
Right.
if this
But it would count it.
It would count it
But that doesn't answer the question then of why it would reject this.
because it didn't fill in enough of the box.
That's my point. How does it know that? I mean, if it would either say there's nothing there, or it would say there's something there. This thing is so smart, it says, it's at 60%. I think I'll send it back out and have them fill in the rest.
There must be some way that the machine. I didn't design the machine.
Suppose this voter had done it right once. It made had carefully made all his marks heavy and black and filled the box, and then checked all the others. They would have counted. The machine, the ballot would not have been bounced. It would have been counted as vote only for that one office.
Correct. That's my understanding.
Okay. Can you go back and tell me very quickly why that regulation that says if it's not machine readable, cast it by hand doesn't apply?
I believe that what they meant on that is if you look at the first part of it, it says if the ballot's damaged, if it's torn by the inspectors, if it's non-machine processable. I believe that's if it were to get stuck in there, not readable, not scannable. I don't think the intent of that part was that it wasn't able to process the vote. It wasn't able to go through the machine.
Is somebody going to talk about the residence issue, or are you going to come back to it?
J.K.'s affidavit ballot.
J.K.'s affidavit ballot, Your Honor, they quite simply, she had innumerable contacts to this area. It's a consistent cycle for her to come back to this area every.
I thought the house is kind of boarded up. That was the basis.
They boarded up during the winter to preserve it from the elements.
Am I wrong that the electricity and water was shut off in August?
That is our understanding, yes. But she was still there. I mean,
And she wasn't even sure she could come back the next summer. She was waiting on how it worked out with the estate.
but her intent was to return back to the next.
So does that mean everybody in New York City who spends every summer with family members in the Hamptons and intends every summer to go back can vote in a town in Suffolk County?
I don't believe that they're staying in their own residence. That they have all to their exclusive selves in that hypothetical.
One can have more than one residence. There's nothing wrong with
Absolutely,
that.
absolutely, and that's typically what she has right now. Is
And
two
one can
residents.
vote in one's summer residence.
So is that the
She didn't own this, though.
She did not own it. No, but
she
had
wasn't
exclusive.
leasing it. She didn't own it.
But she had exclusive rights to it at that time. She was the only one there with her son.
That time being the summer.
Yes, correct. It's basically into the fall. There's
So
testimony.
if I rent a house on Cape Cod every summer for 2 months, I get to vote on Cape Cod?
I believe that well, the difference with that is you have to register there. Here, she was already registered in Chautauqua County through the Motor Voter Act.
But she took another apartment.
She did take another
She
apartment.
moved, correct?
She did, but she did not re-register in that county. She wasn't registered in that
It's
county.
registered out of the other
She's registered out of
summer
Chautauqua County.
address.
Correct.
All right, we understand your argument. Thanks.
Thank you, Your Honor.
Okay. Go ahead.
Good afternoon. Having heard some of the prior testimony, I'm pleased to report I wasn't stopped on the way here, and our record wasn't printed by Kinko's.
Be
I'm
careful
Andrew
going
Goodell.
home, Mr. Goodell.
Yeah, they're still on the way home. I'm Andrew Goodell. I represent Commissioner Brian Abrams. First, with the absentee ballot. There's actually 2 lawsuits that deal with the absentee ballot. The first one was whether or not the envelope should be open at all. And in that lawsuit, both of the appellants argued that the envelope should be opened. And I referred you over to their answers, which are set forth in the record on page 71, for example, where they said, you should open them. We know they're not in this area because the applications were sent to them in Florida. Common
Things
sense prevails.
happened between
What's
that
that?
point and the second lawsuit. They were opened.
That's correct.
It revealed the vote. That's one thing that happened. Another thing that happened, obviously, was that the affidavits were found inside the envelope.
Correct. And at that point,
They
they're
can't
actually
change the position then? They can't pursue an
then
alternative?
that's the second lawsuit. I'm just saying the first lawsuit dealt with whether or not the envelope should be opened because it's a multi-step process. They should not be allowed to appeal that one because they got exactly what they asked for. Keep in mind, at that point in time, Mr. Badel was behind by 2 votes, or 1 vote. I'm sorry. He was behind by 1 vote. These were 2 absentee ballots that came in from registered members of his own party.
He was hopeful.
You bet he was. And
well,
so
putting
he wasn't
that-
about to object to
Now he
counting those
doesn't want
ballots.
them.
Putting that aside, what should be the proper process of the Board of Elections?
Again, I think it's a
There
two-step process.
appears
The
to
first-
still be a problem after Gross in determining what to do when these now come simultaneously.
And I think they should be handled separately. First step of the process, is the envelope, the affidavit envelope, proper? Is it from a qualified voter? For that, you have to have an application on file. And if it's not from a qualified voter, the envelope itself should not be opened. And you don't open it because you want to preserve the secrecy of the ballot. If you make a determination on the first step that the voter is qualified and their application is in and whatnot, then you open the envelope. At that point, you decide whether or not the ballot itself should be open and counted. And at that point, and only at that point, can you actually look at the ballot. They may have signed the ballot or extrinsic marks or something else. That's the second step. The second step, in our case, when they open the envelope, there are now 3 pieces of paper basically on the table. One, the application itself, properly completed, showing they were qualified to vote. Second, the affidavit ballot envelope, which contained the exact same information as the application, because you have to match them up, of course. And then the third was the unopened ballot. In the normal course of events, the unopened ballot would then have been tossed into a pile with all others shuffled and opened ultimately. And in this case, I believe that ballot should be opened because the fact that there was a separate application, completely separate from the ballot, would not have jeopardized the secrecy of the ballot or the identity of that person under normal circumstances.
Well, I think your adversary is saying the board should have never sent the ballot with the application to begin with.
In an optimal
The application
situation,
should have been received first.
Why did you do that?
in an optimal situation, I would agree.
Why did you do
I
it?
can assure you they won't in the future.
Counsel, why did they do it?
They did it as an accommodation. The application came in. The part that was missing was where are you going to be and how long are you going to be out. The rest of the information that identified the voter and indicated that they were registered was properly completed. So they sent it to the voters who were in Florida at the time with a note that said, you've got to return this or your ballot won't be counted. And they did. So in the future, I don't think they'll extend that courtesy, but it was a nice courtesy. In this case,
We should overlook it this time.
yeah.
Do we know if that's regularly done around the state, that both are sent out at the same time? I'm concerned about the next general election as
Yeah,
to
I
how
don't
far
know
we
the
should
answer to
go
that.
with a rule here.
I don't know the answer to that question. I would argue that if you get the application back before you open the envelope or the ballot, if you get the application back before you open the ballot, and it establishes that the voter is qualified, then you should count the ballot. Because the underlying purpose, obviously, of the election law is to count all votes cast by qualified voters.
Well,
That's the purpose.
Before, but this was simultaneous. You're saying that should be good enough. You got the
Well, keep in mind, in the lower court, I argued that they shouldn't have opened the envelope at all.
Right. Everybody's.
My position has
Now
been
that it's been opened, yeah.
right.
But now that it's been open, you think
We
it's
want to count
sufficient that it.
But for the second lawsuit, once it was open, it was separate and distinct. That should not disqualify the
Okay,
ballot.
it shouldn't be disqualified by virtue of the fact that you got the affidavit and the application back simultaneously with the ballot.
That's correct. That act would not disqualify the counting of the ballot. That's correct. If I mention a little bit about the unscanned ballot.
Yeah, go ahead.
Just an aside, I do represent the company that provides all the parts for the mechanical machines. It's still the best machine.
The disclaimer.
It's unbelievable to me that we're going back 100 years of technology back to paper ballots, and this is the legacy that we inherit.
I agree with you. It's much simpler.
And it's foolproof. You know, clunk.
Yeah, right.
You know it's counted. We don't know what's wrong with this machine. Maybe it was too sensitive. Maybe it wasn't sensitive enough. Maybe it wasn't properly calibrated. Maybe it was improperly designed, constructed, delivered. Maybe it wasn't came unplugged or something. I don't know. You know, we don't know what's wrong. But our election shouldn't depend on machines. That's not the mission of the election law. The mission of the election law is, can we ascertain what a qualified voter intended? And the regs emphasize that over and over and
But
over.
from your adversary's perspective, they're saying, well, you got to have rules because this thing is going to be all over the state or this kind of thing.
And we do.
And if people don't follow the rules, then, you know, what are we going to do? And your answer, I gather, is you always try to express the will of the voter. In the end, that's the guiding principle.
Absolutely. That is the fundamental right that we're dealing here. Not a fundamental right to have some machine work or make your election counting easier. The fundamental right is our right to vote. And in this case, by the way, the rules also state that. They say if it's not machine possible,
What about the argument that's not what the rule's talking about?
Well, the rules over and over say if the check mark extends even into a little bit of another box, you read it. If it's not
It's not just if it's torn or...
No. It says not machine processed.
Can I ask you, when would a ballot involving an optical scanner be abandoned? Because there is a reg that talks about
That's right.
abandoned, and it talks about a privacy booth, which I don't know what that is, but
Right.
would there ever be an abandoned ballot with the optical machine?
Yes, you can. When you walk in, you're given one of these paper ballots and a pen or pencil or whatever, and these little booths, kind of like
That
a
you
little...
go in to fill it out?
Yeah, so nobody can see how you're voting. The regs say if you leave your ballot there, you get frustrated, you know. I'm not voting for any of these idiots. I'm sorry. Any of these brilliant people because I can't decide who's the best. And you leave it there in the privacy booth, then it's deemed abandoned. And, of course, the concern is that the next person coming in, if there's a ballot there, they don't want them voting twice.
If I walk out of the privacy booth and I filled in some of it, and I say to the inspector, I don't want to use that optical scanner here.
Right. Under that
Is
situation...
that abandoned, or is that a cast ballot?
Well, under that scenario, by the way, what they are instructed to do is take the ballot that you gave them and insert it into the machine. And in our case, by the way...
Well, presumably it has something to do with what the voter said. If he said, I want to throw this away, you throw it away.
Yeah. You say, I'm out of here, I throw it away. In this case, by the way, the first guy with those nice, neat check marks slid it into the machine. It takes a few seconds for the machine to process. He didn't even know the machine rejected it. He thought it was counted. He turned around and left.
Are there signs that tell the voters
No.
what to do? Well, we're going to have fun next fall, aren't we?
Yes.
It doesn't say, please wait until I say, the machine doesn't say to you, please wait till I say you can go or anything like that?
No.
It doesn't
It doesn't
issue
have a red and a
receipts.
green light that tells you when to leave.
Not even yellow lights. No.
Great. Okay.
If I can mention one last thing
Yes,
on
quickly.
Kent.
Go ahead.
On Kent, this is the affidavit ballot. She testified that she intended to live permanently in a different county. That's her testimony. We asked her, what is your intent as to how long you want to stay there? And she said, permanently. I hope. Permanently.
So your view is she didn't intend to return, period.
No, I mean, that's her testimony.
Okay.
Thank you very much.
Thanks.
But you agree that somebody could have two residences, and you agree that a summer residence could be a proper voting residence?
Oh, absolutely. And if you look at the election law definition, you're dealing with those criteria: fixed, permanent, principal. This court has obviously relaxed the meaning of principal by allowing summer residences,
Right.
but it still has to be fixed and permanent. And in this case,
So we could reaffirm that principle and still find that her residence was not fixed or permanent or...
Well, you have to have two residences
Okay.
before you can choose which one to vote from. And
Right.
And then here, she didn't have two.
Thanks, Counselor.
Thank you.
Thank you.
Counselor.
Good afternoon. May it please the Court, I'm Michael Sullivan. I represent Robert Stewart, who was the petitioner in the first of 3 actions that were filed in this proceeding. And I stress that because in the first action, we were challenging 7 ballots. I had the distinction of losing all 7 arguments that day. However, I was very successful in gaining 2 votes for my client in that loss. The argument you've heard today...
Every vote counted in this particular case. Yes.
When I listened to the argument today on the absentee ballot, it's certainly the argument I would have been making here myself had I not been so successful in losing. But the question was asked, does the court need to do something with the absentee ballots? Well, from my perspective right now, no, you do not. Those absentee ballots were opened. Clearly, the Board of Elections was wrong for sending those ballots out without an application in their hand. But we have not asked you, we have not appealed that decision. And the argument today to try to raise that now on appeal simply is not preserved. The Board of Elections, I think, has the understanding now that they made a mistake. And to ask this Court to take some action now would imply that you need to look at that first action, which simply was not brought on an appeal at the appellate division. There's not an aggrieved party asking you to do anything. My client was the only aggrieved candidate.
Your view of the law is it was wrong to open it, but once that error had been committed, right to count it?
Once it's in, it's counted. Now, on the other hand...
Why is it wrong to do one thing and right to do the other?
Well, again, I would have argued to not allow it.
I don't know what you would have argued. What are you arguing today? Why is it wrong to do one thing and not the not the other?
I'm not going to tell you it's not wrong. However, they didn't file the appeal. They didn't bring it. They weren't aggrieved. They received what they wanted to receive.
Okay. Assume that
Is
if
it
they
improper? Yes.
assume that if they had done that, they would prevail. That you were right. So assume you're right in everything. You're right the first time. You're right the second time. But even though the first time you were saying don't open it, and the second time you're saying count it, why are those two distinguishable? Why is it not okay to open it but okay to count it?
It's only a proper now on a procedural issue. Clearly, I argued that it should not have been counted that day.
Why is that? Why? Don't know what you argued. Tell me why one is okay and not the other.
Once the decision was made to open those, they're open. Unless somebody under election law files an objection or makes an objection to that ballot and preserves it for appeal, there's nothing to ask a court to take action on. I'm sure that there are other times. There were other cases that day where a ballot was open and there were objections that could have been made but weren't made. Or in other races where it wasn't as close, there were objections made, but nobody went to court.
Well, you're really saying that once it's opened, it is counted?
Once it's opened, it's counted. They have the opportunity to challenge if they wish for a new reason and then go to court and get their action started. They indeed did start an action.
If I understand your point, it's that the defect went only to the envelope before it was opened. Once it was opened, it was a perfectly good ballot?
That's my argument at this point, yes.
Now, if you were to lose on this argument, you would be down – you would still be up by 1, right?
Yes, Your Honor. Yes. But we, again, the second action was never commenced. There was actually, there was a second argument commenced, but that had to do with the fact that there were the 2 items in the envelope. And as it's been pointed out, those envelopes were opened. The ballot fell out separate from the application or whatever the other document was, because the record really doesn't state or doesn't have a copy of that in the record.
If an absentee ballot comes in and the board just overlooks something on the application, you know, they use an inappropriate reason for why they want to use an absentee ballot, does someone have to object to that?
That would be in my position, yes.
So your position is as long as nobody objects to the absentee ballot, that gets counted?
Correct. I assume there's some internal mechanism the board can handle on its own, but to bring it to court, somebody has to make the objection. I think the election law is clear on that. The final argument with that ballot, though, is under Election Law 9-112, and clearly the document was not folded inside of the ballot. They were able to be separated, and the confidentiality was not ruined by the opening and finding that paper there, because that paper was enclosed in an envelope that had the voter's name, registration, address, and signature on it. So it wasn't really a confidentiality question.
And that's the envelope that would have housed the ballot had the ballot been sent alone.
Yes. With the unscanned...
So did you folks, I don't know if you were there when they were looking at the ballots, but whoever was there, did they look at the application before this ballot was opened?
There was an application filed before the ballot went out. It wasn't complete, so they sent a new one to the voter.
Right. I mean, when they open this envelope, and two things fall out of the envelope. We've got the ballot in another envelope and the application. When they were doing the canvass, do we know if anyone looked at the application before they opened the ballot envelope?
When they opened the envelope, they pulled out the two documents. They did pull out the piece of paper. The two election commissioners looked at the document, indicated to everybody that that was the application that everybody had expected would be returned with the ballot.
So they knew an application was there. Okay.
They didn't share that and pass that around the table. They only shared the results of the ballot and passed that around the table.
So nobody was able to object. No one really had an opportunity to object.
Well, not to the ballot, not to the application at that point, no. No, it did not come up.
But there was nothing wrong with the application? Except that maybe it should have been in sooner.
That was the argument in the initial case. I don't know about the application that came in. I don't know if there were any objections to it. We never had that passed around the table to look at.
So the objection is first voiced in this lawsuit number 2.
Yes. Yes. With the unscanned ballots, Your Honors, there are rules put in place. Appellants would ask you to set up a new rule, basically putting the burden on complying with the new machines on the voter. I think if you read through the rules that we've cited, clearly the rules put the burden on the Board of Elections to assist and get these ballots counted. There's no question that the ballot was placed into the machine, two ballots, numbers set 37 and 38 in the exhibits. They were put into the machine, and for various reasons unknown to anyone at this point, they didn't get counted. Now, that's much different than the 26 other ballots that during the day were voided and marked spoiled. Now, there was testimony that some voters redid their ballots, and in order to get a new ballot and redo one before you were counted, they had to get a new ballot and mark it spoiled. We don't know if anyone actually in that 26 left their ballot in the privacy booth, but that would be another reason to mark it spoiled. There simply is nothing in the rules that were adopted for this election by the State Board of Elections to put the burden on a voter to wait.
So it's the board's duty to make sure that the votes are counted.
Yes, and it clearly says if that isn't counted by the machine, a bipartisan team gathers together and makes the count. That happened at the Board of Elections when they were returned. Ironically, to be arguing about the rule is a little of a stretch, too, because the original petition had to do merely with the chain of custody. When action number 2 and number 3 were commenced by the appellants, they were arguing that there was no clear chain of custody. Now they're arguing an argument that really wasn't offered at the trial level, was brought up at the appellate division the first time. There was simply a chain of custody, and the record shows that those ballots were taken by a bipartisan team, put into a slot, returned to the Board of Elections under a seal, and the only issue that was really preserved for appeal was a chain of custody. And if you look at the record, clearly the chain of custody was established.
You don't disagree with the board that if one of these cards or ballots is left in the privacy booth, that that's abandoned?
Absolutely.
But
at that point, you have no idea who left it there. We have no idea if they intended to. We don't know if they went back and got another piece of paper and filled out a new ballot.
But you don't think it's abandoned if it's spit out of the machine?
It simply hasn't been cast by the machine. It was brought and delivered to a machine for casting. It wasn't left behind. It wasn't meant to be discarded. It wasn't as though somebody had thrown it away or simply came in, got it, and left. That covers a situation when they don't know who it belonged to. In this case, the testimony was clear. They knew who these two ballots belonged to. One gentleman stood there and said, "I want it counted." The other had already left, and they knew that those persons had intended and attempted to put that ballot into the machine for the reading. If I could just briefly on the residency, we took plenty of testimony from a woman who clearly has some connections to the town of Ellington, but she simply does not maintain two residences. She doesn't have a second residence under the law to even pick which one she would want to vote for. It was clear her residence is in Cattaraugus County in Randolph, New York. She had left this property. She has no rights to come back. And she was pretty clear that the family wasn't making it easy or giving her a clear opportunity to have that property. She simply doesn't have two to pick from. All of the cases cited by the appellant are situations where people with wealth have two residences and get to pick.
Okay, Counsel. Thank you. Okay. 2-minute rebuttal. Go ahead.
Yes, thank you. As to the residency issue, the Chautauqua County Board of Elections qualified J.K. to vote by affidavit ballot, marked her as a transfer. The 2 inspectors approved her, and the election commissioners never, ever overturned that determination. From my point of view in the case law, Hoseley specifically, the decision of the Board of Elections is statutorily deemed presumptive evidence of her residence for voting purposes by affidavit.
But it can be rebutted, right?
Pardon?
Can be rebutted, the presumption, no?
Correct, but there's not sufficient, as the dissent held from the appellate division, there's no record evidence to support that rebuttal. As to her intent to return, the record evidence is as follows. Question, do you intend to return there to the town of Ellington? Answer, probably this summer. Next page, would you like to continue if you could stay there? If I could, yes. I want to address Judge Graffio's point, I think is well taken.
Isn't if I could, yes, a funny thing to say about a place that's your residence?
I'm sorry?
To say, I'd like to go back there if I could, a funny thing to say about your home?
Yeah, no, it's absolutely consistent with what is going on here. This is a family residence for generations and generations. She's had the benefit of living there for the last 3 summers.
I thought they were looking
she wasn't
to sell
there 2
it.
months.
I thought the aunt was looking to sell it.
Possibly, but
Isn't that why she gave a conditional answer?
Not sold yet, still up in the air. She couldn't commit. This is a nice cleaning lady telling us, as best she could tell us, what she thinks might happen. But there was nothing definitive about that. When she was asked what her intent was to go back there. She's been living there every summer for the last 3 summers, rent-free, and it's benefited her. Judge Graffio, you mentioned earlier a point that I want to address very quickly. So what happens, and this is the issue for this court, what happens if the voter says, if the machine doesn't take the scan, if it doesn't scan in, or let's say better, what if the voter says, I don't want to deal with this machine. Here's my ballot. We're going to have anarchy in the scanning system. You're going to have thousands and thousands of ballots if the voters all say, I'm not going to wait for it to scan in. The Board of Elections set up a procedure consistent with the federal law to set up a new procedure. We're from Jamestown. We love the automatic voting machines. However, the rules are the rules and the law is the law. We're going with a new system. You have to be patient. When you go this Friday to deposit your paycheck in the ATM, you put your deposit envelope in and you wait for it to go in. It takes seconds. Same issue. Thank you.
Counsel, go ahead.
Thank you, Your Honor. If we go back to the absentee ballots, it should be noted that if, under normal canvassing situations, the minute the application would fall out of an envelope, that ballot would be thrown aside, it would be void. I mean, that's just the way the Chautauqua County Board of Elections, and to my understanding, all Board of Elections have handled that process in the past.
Your opponent talks about preservation on that issue. Is that a problem?
I don't think there is a preservation issue on the objection because actually Mr. Sullivan was the one who raised the objection. My client turned around and said we're not hearing any objections at this time because we're court ordered to come back in here and to investigate to see what's in the envelope. It was preserved for any objections. Everything in the envelope was actually paper clipped together and we looked at every ballot individually so that any objections can be raised, and they were raised by Mr. D'Angelo in his second and consequently third order to show causes. Which brings us to, with regards to the unscanned ballots, Mr. D'Angelo, in his order to show cause for his client, asked the Supreme Court to determine the validity of the optical scan ballots counted by the Chautauqua County Board of Elections, which were not cast in accordance with New York State election laws, rules, and regulations and policy. We weren't simply worried about the chain of custody. Quite frankly, we didn't know what happened that day. It's a brand new process. We had to have testimony come in. We heard testimony from the poll inspectors that day. We needed it. We needed all that testimony to determine what happened. Also, it should be taken into account that these ballots were put into an emergency slot. I don't necessarily see this as being an emergency. The emergency slot is used for when the power goes out or the machine continually kicks back the ballots. At that point, it's put in the emergency slot. Once the machines turn back on, the bipartisan poll inspectors are to place the ballots back into the machine and have them be scanned in. Thank you, Your Honor.
Okay, thank you all. Appreciate it.